San Diego County's climate action plan won't get the job done, according to an appellate court ruling this week. The court said the plan failed to provide detailed deadlines and enforceable measures to ensure that greenhouse gas emissions will be reduced. I'm joined now by Attorney Jan Chatham-Brown, who represents the Sierra Club. We should say we asked the county to send a representative to the show. The county declined. Jan, what specific deficiencies did the Court of Appeal find with the county's climate action plan?
Oh, there were a myriad of problems with both the process and the plan. But essentially, the problem was that the plan that was adopted, the climate action plan, which had been committed to as part of the general plan update process, didn't deliver on the promise the county had made. The general plan update allowed additional growth in the county. And under the California Environmental Quality Act, or CEQA as we commonly call it, any public agency is required to evaluate and mitigate the impacts, the adverse impacts, as the result of any project. In this case, they acknowledged adverse impacts, but said they would mitigate it by doing a series of things that were adopted as mitigation measures, and the major element of that plan was going to be adoption of a comprehensive, effective, and enforceable mitigation climate action plan. Unfortunately, the county failed to deliver on its promise.
So the Court of Appeals ruling upheld the trial court's ruling in this case. Now, what was the county's argument throughout this legal challenge?
Well, they had a lot of technical arguments that we didn't comply with the statute of limitations. They alleged we were challenging the general plan update, and the statute of limitations for challenging that had run. But in fact, we were trying to enforce the promises they made as a result of the general plan update, and the court agreed with that theory. They had technical arguments about the standard of review, and the Court of Appeals said, under the standard of review that we said was applicable, or the standard of review that they were arguing for, we still won, because there was no way that they were complying either with CEQA or the promise that they made as part of the general plan update.
So did the Sierra Club point out some of these deficiencies during the drafting of the climate action plan?
Well, unfortunately, there wasn't really much of a public process. In fact, the Sierra Club was alerted to the fact that the matter was coming on the agenda as a result of a call from somebody at KPBS. But the Sierra Club had previously submitted detailed recommendations for what should have been included, and continued to argue for that. Even after the lawsuit was filed, the Sierra Club made repeated efforts to get the county to incorporate some meaningful provisions and settled the case, but the county declined to do so. Now they will have to have a public process, and Sierra Club and other groups should be at the table to be sure that the plan that they ultimately, that the Board of Supervisors ultimately considers, will achieve the emission reductions that we so desperately need.
So now the Sierra Club's lawsuit is one of two lawsuits against the county on their climate action plan.
Well, not against the county. There's a parallel suit involving a challenge to SANDAG, or the San Diego Association of Governments. And that is with regard to not their climate action plan, because to the best of my knowledge they don't have one, but to their transportation plan and the environmental impact report that it was based upon. Ironically, the same trial court judge ruled in favor of the petitioners, Sierra Club and others, including the California Attorney General's office, in the SANDAG case. Both of them have been under submission for quite some time. Our decision came out yesterday. We're still awaiting the decision in the SANDAG case.
So basically now the county has to go back to the drawing board and get public input for their climate action plan.
Yes.
Does the court's ruling in any way affect the city's climate action plan?
Well, I think the court's ruling affects every city and county throughout the state. It's very clear that mitigation measures, once they're adopted, have to be enforced. And there haven't been many cases, appellate cases, on this issue. But this is a very clear statement, and it's a very strong statement that the Court of Appeal understands what the science shows and wants the agencies to comply with it.
Jan, thanks so much for coming on the program.
You are very welcome.